Welcome to today's video. I'm Richard Chapo. I'm an attorney down in San Diego, California, and I've been advising online businesses for about 20 years now. The subject that we're looking at today is copyright and the DMCA. Before we get into it, let me apologize about my voice. I have a bit of a cold, or apparently I'm going through maturity for a second time. I'm not sure which it is, but I did not smoke a pack of Marlboro Reds last night. For some reason, my throat is just trashed. I have no idea why, but maybe it's just the winter. So I'm sure you're fascinated in all that. So let's get to the DMCA. What is the DMCA? Well, to understand it helps to look back a little bit in time to focus on where it came from. So we're in the mid-1990s. This internet thingy is starting to gain some attention in people. It's not a commercial medium yet for any real intents and purpose, but people can look at it and see, in the next few years, this thing could blow up. And so one group that was looking at it in particular was the World Intellectual Property Organization. As their name suggests, they are an organization that looks at and addresses intellectual property issues, puts forth guidance, things of that sort. The United States is a member of that group. And so what WIPO, they're known as WIPO, what WIPO was looking at was, well, how do we protect copyright owners on the internet versus protecting the exchange of information? This new medium really, in many ways, could theoretically do away with borders and countries. And so it would be very hard for countries that really restrict information access to their citizens, to do that when there's this internet. And so they came out with the guidelines that basically talked about a balancing act and trying to create a scenario where, the rights of copyright owners are protected versus, the exchange of information. So let me just talk about those two positions. Copyright and the exchange of information is something that typically you're going to have a strong feeling about one way or the other. So if you believe all information should be exchanged freely, I understand that, but you also have to think about, some copyright owners, it's not really fair to them. I mean, imagine if you just spent a year writing your first book and you get it published and you're happy as can be, and then within a week you see it being, reproduced and stolen and resold everywhere. And you're not making a penny off of it. All that hard work, all your dreams, and you're not getting jack. You're going to be pretty unhappy. And I think it's reasonable to suggest that people in that situation should be protected. Now, conversely, we absolutely want to make sure information flows online. That's really kind of the utopian view of the internet and what it should do. So trying to come up with a balancing act, I think, was a prudent approach to dealing with copyright online. Is the DMCA perfect? Not by a million miles. There are all kinds of problems with it. But those problems could be fixed if we had the political courage in D.C., which, as you probably noticed, we don't. So that's obviously a topic for another video. So what is the DMCA specifically? Well, so after the WIPO issued their guidelines in 1998, a piece of legislation known as the Digital Millennium Copyright Act was introduced in Congress. It was approved and passed later that fall, and then in October it was signed into law by President Clinton. And the Digital Millennium Copyright Act deals with three subjects. One, digital rights management. Two, internet service provider immunity. And then three, the application of royalties to the playing of music online. The first and third subjects we're not really interested in for the purpose of this video. We're going to focus on the second one, which was the immunity provision. It's known as Section 512. So what does this say? Basically, it says that as long as you follow a particular compliance process, an internet service provider cannot be held liable for copyright infringement claims based on content uploaded by a user. So what's an internet service provider? Courts have defined it very broadly. It's everything from a website to an internet-connected app to the cable company that maybe you're using to access the web now. Anybody that's basically going to get you online and transfer information. And now the key to this immunity, again, is you have to follow a specific compliance process. But if you do, you cannot be sued for copyright infringement for monetary damages. Now, you can be sued for a temporary restraining order or some kind of a court order to prevent you from taking a certain action in relation to copyright. However, in the 20 years since this law was enacted, I've never once heard of anybody ever suing for anything other than monetary damages. So this immunity is incredibly important, and it really gives you, as a website owner or an internet-connected app owner, the ability to insulate yourself from some of the more frequent copyright infringement claims that we see online. And you'll notice when in discussing it, I never said anything about it costing anything. And in fact, it really doesn't. You do need to designate an agent, which we'll get into. And the cost of doing that with the Copyright Office is a whopping, staggering, outrageous $6. So we're talking about, immunity for a very cheap price here. And it's really, if you're allowing users and visitors to your online platform to post anything, even just comments, you should take advantage of this law because it gives you immunity. Why wouldn't you? This is one of those freebies that everybody, should be registering for. So what about the compliance process? Well, the compliance process is where we get back into that balancing act. How are we going to protect copyright owners versus, ensure the free flow of information? And so the compliance process requires a copyright owner to submit what's called a DMCA takedown notice to the website or app or internet service provider in question. So let's look at Facebook. It helps to do this more with an example than just to talk about it in a vacuum. And let's assume I go out to a website. Let's say I go to Deadspin. I copy one of their articles and I post it on my Facebook page. Okay, Deadspin gets wind of this, and they would then file a complaint with with Facebook, and they would go look for their DMCA agent on the Facebook site and submit the takedown notice. Now, at that point, Facebook is required to take down the content that I posted automatically. There's no choice there. And then they will contact me and they'll say, hey, nitwit, we received a DMCA takedown notice regarding this content you posted. This is essentially a copyright complaint, an infringement complaint. And then at that point, I have to decide, am I going to contest that complaint or not? In 95% of cases, the answer is no. That'll be the end of it. So at that point, the copyright owner's happy because the content's been taken down. Facebook's happy because they're not getting sued for infringement. And I'm happy because I probably didn't realize I was infringing on the content in the first place. And I was worried I was going to get sued when I get the notice, and nothing comes of it. Now, however, I have the right to file a counter notice as the user, as the person who posted the content. And in filing the counter notice, I would essentially be arguing that the copyright owner is mistaken or didn't understand, the situation, and that I had a right to use that content. So how would that arise? Well, typically it'd be a fair use defense situation. We're not going to get into fair use. That's a whole other subject. But one of the understood fair use defenses is criticism. So maybe if I took that article from Deadspin, I posted it on my Facebook page, and then I wrote, a big blurb about why the article was wrong, why the author was out of his mind, and here's how it should really work. It's a functional criticism. Well, under copyright law, the DMCA, or any copyright law in the United States, we want to encourage criticism. Again, we're talking about the balancing act, the exchange of information, and that's how that would play out. So at that point, Facebook would send the counter notice to the copyright owner and say, hey, we received a counter notice. At this point, your bluff has been called. And the copyright owner would either have to go file a federal lawsuit for copyright infringement against the user who posted the content, that would be me, or they'd have to drop the matter. And it's really that simple. So the advantage of all of that is it's an informal process for dealing with the claims. And in a vast majority of cases, the claims are dealt with during that compliance process. And so it helps keep the courts from being bound up in a zillion different copyright infringement lawsuits. Now, if you're savvy or you've dealt with the DMCA, you may be saying, wait a minute, some sites don't follow that compliance process. So for instance, YouTube has their own content ID system and their own DMCA kind of approach to copyright infringement. And in many cases, they do not follow the compliance process exactly. So if I submit the copyright owner submits a complaint about a video I upload to YouTube, sometimes they won't take it down automatically. And that's because they're evaluating it and they just decided that the claim is nonsense. Google does this as well. I imagine Facebook as well. And the reason for that is some companies use automated software to issue complaints, and the complaints are just obviously wrong at certain points. They're not valid and what have you. And quite frankly, those companies, Google, YouTube, which is really Google, and Facebook have so much money and so many financial resources online, they don't really care about the immunity. I mean, if they got sued for copyright infringement, let's say they got hit for $5 million, well, that's pocket change to those companies. It's not something that's going to be a problem for them. If you're listening to this, hopefully you're making that kind of money, but statistics suggest you're probably not. And if you got hit with a judgment for $5 million, it would probably be a really, really bad day. So complying with Section 512 is a great way to go. Now, a couple of odd things about this. The DMCA Agent Service. Why do I have that up there? Well, under the DMCA, you must designate an agent. And this agent is, the purpose of them is to receive the takedown notices. Now, the funny thing about the agent is that they're listed on your website, or your app. They're going to be listed. It's going to be their name, their street address, phone number, and email address. And this person's also going to be listed in an online database maintained by the Copyright Office. And these are all things the public can look at. And so the question becomes, well, do you really want that information out there? At a minimum, your email address and your phone number are going to be picked up by bots, and you're going to be hit with endless sales calls and spam. And that's just kind of the nature of the web. In a worst case scenario, you can have people showing up at your house. And that's something you really typically want to avoid, even if they're quote unquote fans, stalkers and creepy people and what have you, generally should be avoided. Now, if you run a website or an app that is in an area where there's some debatable content or contested issues, then you have a real potential problem, because you don't want somebody who's angry showing up at your door, particularly if you have kids or something like that. It could be a problem, and we've seen it in the past. And this is also true if you are in the adult field. So if you are a model or an actress or an actor or what have you, then you really don't want these kinds of people showing up at your door, because it's probably not going to work out well. So you can use third-party DMCA agent services. Full disclosure, I own one. It's called DMCAagentservice.com. I know, very creative name. And you can have somebody else act as your agent, and it's usually $70 a year or so. If you have an attorney that you're using full-time, that attorney will often do it for you for free. So take a look at those. And then D, protect thyself. So the DMCA is controversial. If you go online and you start reading articles about it, you're going to see people who hate it for one reason or the other. And that's fine. I understand why. For copyright owners, it's frustrating, because a lot of times, even if you get your content taken down on one site, it may suddenly appear on another site. And it's hard to deal with that. You're basically playing a whack-a-mole situation. If you're somebody who has reposted some content, even if you feel you're in the right and you have a fair use defense, you probably don't have the $100,000 to defend the lawsuit that could arise out of that. And so that seems a bit unfair as well. I understand all of that. And they're valid criticisms. But if you own a website or an app or any kind of internet platform or service provider, you don't care about those issues. They're not germane to how to run your business. What you want to do is comply with the DMCA, because you want to take advantage of that immunity. You're basically getting it for free. The only cost, if you act as your own agent, is $6, and that's the filing fee to register the agent with the Copyright Office. That's it, $6. Even if you use the DMCA agent service I have, that's $70 a year. So we're talking about nominal cost, and you're getting essentially insured against one of the most common legal complaints that we see online, which is copyright infringement. So protect thyself. Take advantage of this. If you let users post anything to your platform, even if it's just comments, go ahead and comply and make sure that you protect yourself so that, you can avoid these claims. And they come up all the time. Google gets something like 8 million DMCA takedown notices. I think it's either a month or even a year. But whatever the time range, that's a lot of complaints. and you can sidestep all these issues just by complying with the DMCA. So that's it for today. If you have any questions or comments, please contact me at my website, SoCalInternetLawyer.com. That's SoCal, like Southern California, internetlawyer.com, and I'll be happy to answer them. Just use the contact page. Otherwise, I hope you consider subscribing to this channel. We'll be issuing all kinds of videos related to internet businesses and internet law in the future. And I believe that's it for today. So hopefully my voice will get better, and we'll see you at the next video. Thanks.